Our top story today, the questions that linger. Lots of questions, lots of confusion for same-sex couples who came to Canada from other countries to get married. We want to try to bring you some answers on this today. Andrew Feldstein is with us, a family law lawyer, not with any particular cases involved in this, but with an expertise. So we turn to him for that, and thank you for coming in today. There is so much confusion after the revelations yesterday about this court case and the question about whether this lesbian marriage was ever a legal marriage to begin with. Is same-sex marriage in Canada at risk?
In my opinion, it's not. I think the argument that was advanced by the Justice Department in court was a very weak argument. There are two reasons why the Justice Department could say that a couple that doesn't reside in Canada, or I should say they said there were two reasons why, a couple that's a foreign resident should get a divorce here and should not get a divorce here in Canada. The first reason is a legitimate reason. The Divorce Act says in order to ask for a divorce, you have to be resident in a Canadian province for 1 year.
Right.
They weren't resident here.
You don't have to have a residency to get married, but you do have to have a 1-year residency to be divorced here.
Absolutely. And that argument makes sense to me. The second argument, which is the one that's caused the controversy, is saying that it may have been valid here, but if it's not valid in the place where people reside, then it's not valid here either. And in my opinion, that doesn't make any sense whatsoever from a legal standpoint.
Well, a lot of people say it is illogical because it seems to indicate that Canada's saying that the laws of another country trump Canada's laws and indeed Canada's constitution. So what validity could there be to that?
Well, I find it a troubling argument because when you look at the actual test of what makes a valid marriage, there are two elements to it. One is called the essential validity, which is the idea that you can give your consent to get married. You have enough knowledge, you can consummate the marriage. And the other part is called formal validity. Formal validity is that it's a lawful marriage where it took place. So these marriages, if they took place in Ontario as an example, were lawful based on Ontario law, and therefore, in my opinion, they are lawful. So this argument, I don't understand it, and I don't know why the government would even advance it.
Well, that is the question. Why would the government advance it? How could this happen? A lot of times there are mistakes that some enterprising lawyer wants to, exploit and use for his or her own argument. Do you think it was in case of that this time, or is there something more insidious backdoor going on?
I would like to think, and I do believe, that it may be just the lawyer who is advancing the argument thought, I'm going to try this creative argument in court on this particular day, and didn't think about the politics of it or the ramifications of the statement. And from everything in the news, it sounds like the Prime Minister was surprised yesterday morning when he was first questioned about it. That leads me to believe it may have just been a decision of an individual lawyer.
Rob Nicholson, the Justice Minister, has said he's going to look at this quickly to clarify the situation and make any changes. Legally, what can he do?
The change he can make is to create an exception for those people whose marriages are not recognized in their home jurisdiction that would permit them to apply for a divorce in Canada and waive the requirement for them to be resident in a Canadian province for 1 year. And
so there are simple legal remedies, but would they not have to also get into this whole residency hornet's nest? I mean, if looking at that whole residency requirement for divorce, which could have whole other complicated implications as well.
I think you just carve out the one exception that says if your marriage that occurred in a Canadian province is not recognized where you reside, then we'll waive the 1 year requirement to apply for a divorce in Canada. And I think that'd be a very simple exception, and I think it would probably go through Parliament very quickly if that's what they intend to do, and that's what the Justice Minister indicated they're going to do.
All right. So today, if you get a phone call from somebody saying, I don't know about my status, it could be, maybe you can take us through the scenarios, an out-of-country couple who came here to get married. Are they legally married? In
my opinion, yes.
Okay. What about Canadian same-sex couples who were married here?
Clearly, yes. There's no doubt about that.
That's not in dispute.
That's not in dispute. The only risk that could happen, as was raised in your commercial earlier, which is a Canadian couple that's resident here, and then they move to a jurisdiction that doesn't recognize their marriage, would be suggesting that their marriage is no longer valid. And that's one of the reasons why I think this argument doesn't make any sense.
Okay. But if it doesn't make it's one thing not to make any sense. It's another thing to proceed with it. They might want to proceed with an argument that doesn't make any sense, but still.
Sometimes lawyers will try lots of arguments and hope something resonates with the judge hearing the case. They may have thought they're going to advance this argument. It has a low possibility of success, but give it a try anyways. And some lawyers will do that, and perhaps that's what happened.
Thanks for coming in this morning. Really helpful as we clarify the story that everyone's talking about in the country.
Thank you for having me.
All right, Andrew Feldstein here in Toronto with me this morning.